On the conversation of that merit rule that the Judicial Committee of the Privy Council has indicated, Director of the Mona Law Institute, Dr. Christopher Malcolm, says the government must carefully examine the new rules being proposed by the Judicial Committee of the Privy Council, the JCPC, regarding appeals. Dr. Malcolm says the adjustments could have serious ramifications for the constitutional rights of Jamaicans. The proposed adjustment is being made under Rule 22. It says where permission to appeal has been granted, a single member of the Judicial Committee will review the appeal. If the member considers that the appeal is devoid of merit, they will invite the appellant to file submissions to show that the appeal has merit. This will take place in front of a panel of 3 who have the right to dismiss the appeal if it is found without merit. Speaking on Nationwide this morning on Friday, Justice Minister Delroy Chuck said the proposed merit rule by the JCPC is a common sense position that he supports.
It just seemed to me to be a common sense position. And I'm really disappointed that, arguments are being put for or against it. If a matter is devoid of merit, why is it being pursued? A single judge having said it is void of merit, then at least one opportunity is given to the appellant to put in the arguments that could persuade a panel. Having done so, a panel of 3 can make a decision.
Minister Chuck says the JCPC is simply trying to ensure there are no unnecessary appeals, even where there is a right of appeal. According to him, the practice of only proceeding with cases that have merit has been done in the past by the JCPC.
What is being done by the Privy Council is to save the appellant a huge amount of money, because if the appeal went through and you cause the respondent to participate and the appellants lose, they will have to pay the cost of the respondent. So it seemed to me just a common sense position that they have put in writing. As far as I know, this has been done in the past.
That's Delroy Chuck, the Justice Minister. Well, the Director of the Mona Law Institute, Dr. Christopher Malcolm, has joined us this morning. Good morning, Dr. Malcolm.
Good morning, George and Tona, and to your listeners and viewers wherever they may be.
Excellent. The Justice Minister, we put it to him last week that, look, this screen that is being put in front of the access to justice by way of the right to appeal that is in the Constitution for Jamaicans, this is not right. He's saying it's much ado about nothing. There's nothing wrong with what the JCPC is seeking to formalize. Your position?
Okay, let me start by saying that the minister's very utilitarian approach is not one which is necessarily wrong. Is it good sense to weed out things that say you have a right of appeal for things over $1,000 and so on? I quite agree with him on that. The problem I have, which is what I think the minister probably should focus a bit on, is the extent to which the rule change and the way in which it has been gone about or is being proposed undermines our Constitution and our legislative process. That is my significant bone of contention. And let me tell you what happened. We very often argue, and I suspect the minister did not reflect enough on this either. We very often argue without remembering that the Privy Council, and by extension Lord Reid, is the head of our judiciary, of the judicial branch of government. Now, every branch of government is subject to the Constitution in how they conduct themselves. Now, what happens here is that we see rules being implemented and changes being made, which have not gone through the process of our legislation. Now, what happens in Jamaica, we have what we call the civil procedure rules. The last would have been come about in 2002. And those rules have been implemented pursuant to legislation, which is what our legislative design provides for. Now you have changes being made in our judicial branch by the head of our judiciary. Forget what you hear persons say about our Chief Justice being head of our judiciary. That is not true. It is Lord Reid. And what we now have happening is that change is being made without the legislative intervention, where at local level that could not have happened. Now, what is the mischief there, and how undermining of our process is this? There is my primary bone of contention.
Well, go right there. Well, go there after the break, Dr. Malcolm. We're up on the break. We're talking about that JCPC review merit appeal rule that the Justice Minister says has been in practice, but is just now being formalized, given the recent developments. And that, look, it's not an obstacle to the access of justice or the right to appeal. It's a common sense approach, is what the Justice Minister says, but legal scholars have disagreed with the Justice Minister.
Still tuned into the front page, having a conversation with the director of the Mona Law Institute, Dr. Christopher Malcolm, about that JCPC merit rule in terms of reviewing appeals before they actually go to the court for hearing. Welcome back to the program, Dr. Malcolm.
Thank you very much.
Just to understand something you were saying before the break, you're saying that the merit rule that has been put in place now, or has been approved to be put in place by the JCPC, that or people here or legislators here would need to make some changes in the Constitution if that was to be what goes ahead without any issues.
No, I'm saying something a little different. Yes, that is correct, yes, but I'm saying something a little different as well. And the reason I've gone the other path is that most of the focus is on the straight constitutional point. I'm more focused on the nature of governance, which is where my focus is now. And to be clear, the minister taught me constitutional law when I did law first year, several years ago. So this has nothing to do with his capacity for understanding the Constitution. But what I'm saying is, every arm of government is subject to our Constitution, and there are established procedures under our law as to how things are to be done. When it is that the Privy Council is sitting or functioning in relation to Jamaica, it is not doing so as the Privy Council of the United Kingdom. It is doing so as the Privy Council of Jamaica, and therefore subject to our laws and our procedures. Now, in Jamaica, there's a method by which rules of court are implemented, and they are implemented pursuant to legislation, and that process has typically and traditionally included consultation between bench and bar and among other persons as well, and done for the public good. What we have seen happen is that we hear of rules that are to come, and the question I ask you in the media, have you heard of any consultations to involve bench and bar in Jamaica or the public generally about rules that are being implemented to affect all of us in a manner which, in my view, is contrary to how we do things in Jamaica? And remember, I just said, the Privy Council in this context is not the Privy Council of the United Kingdom, it is the Privy Council of Jamaica.
We have not heard any consultations being done. So you're saying that should have been done before they come with these rules that are going to affect Jamaicans who are seeking an appeal?
There are established constitutional rights of access to the court and all of these things being done. And what people sometimes forget, or what all of us very often sometimes forget, is that the court is not simply a place where you go to have basic disputes resolved. It is a critical arm of government which affects sustainable economic development. It affects the rights of the citizens, yes, but it's much more. And if you trace the history of the courts, for example, even the United Kingdom, since AD 1066, you will see the critical role that courts have always played in sustainable economic development and in the development of nations, not just there, but wherever you go.
But data is the problem, though, Dr. Malcolm.
Focus our minds there.
Data is the problem, because I asked the minister last week, okay, give us an idea of the number of, I don't want to call it this way, but for ease of understanding, let's go with this descriptor. The frivolous cases, then, that have gone before the Privy Council, sufficient for this thing that has been done in practice to now be formalized. In other words, the Privy Council has said, look, Jamaica has been sending us too many of these cases, which really the merit is weak, and we waste our time adjudicating on these cases. So let's formalize this mechanism where those are weeded out, and only the ones that are worthy of consideration pass beyond that hump. I without that data, it's not making much sense to me.
And George, let me tell you something. That's an excellent question, but you should have asked me an even broader question. How many appeals other than pro bono appeals leave Jamaica to the Privy Council every year?
That's another
Very
one.
Few. Very few. And I say this much, that every lawyer in practice will tell you that there are many times where clients come before you. They have what appear to be good cases that could go forward. You simply will look at them and say, sorry, I don't think you can afford to take this to the Privy Council. There are many cases which are weeded out locally for the persons who then end up going to the Privy Council. Contrary to what the minister may be saying, are persons who have already been counseled on the cost implications and have decided that they have a right which they wish to pursue. Let me give you one good case. Several years ago, Paul Beswick, now deceased of counsel, had brought a matter involving a traffic ticket all the way to the Privy Council, and he won. That could have been considered frivolous, it could have been considered everything, but it established a critical point.
Yes.
And what should have been done. So the fact that something is of simple value or something on the face of it does not mean there is not a justiciable right which should be taken to finality. And
here's the other point now, Dr. Malcolm. The legal scholars, well, practicing attorney, Mr. Leiber, we had Emil Leiber last week, and we had also the president of Jambar, and they were saying that, look, I know that you have gone, looked at another angle, but the central argument that they were making was the constitutionality, because they're saying that what is being proposed to be formalized does not reconcile with what the Constitution says about the right of appeal, because now there's a screen door between a Jamaican and the Privy Council that ought not to be there, and the Constitution makes no allowance for a screen door to be placed there, and that is wrong. The Justice Minister doesn't believe that.
And I'm fully in agreement. In fact, I read yesterday an editorial at a particular place, and since they haven't acknowledged us, I don't think I should hear that the issue of this constitutionality and the rules was raised by Mike Hilton of Council in October last year. Let me be clear. That event was one which I organized and which happened at the Mona Law done by the law schools of Norman Manley and Hugh Wooding, class of 97, and the Mona Law that put it on. We put it on. And that issue was raised in an event that I moderated. So I'm well aware of that constitutional issue, but I'm saying beyond that, and the bigger point for me almost, is one to say there is a process. The Privy Council is subject to our laws, and the Privy Council should be acting in a manner which is compliant with our laws and our procedures.
But hold on, Dr. Malcolm. I don't want you, I hear you on that, but listen, there are so many people who have cottoned on to this point of the reconciliation between what our Constitution says and what the formalized rule will be. So I want you to just spend a little bit of time to address that frontally, because many people hold the view from the eminent council that, you know, this thing, it doesn't marry. Yeah, there's a lack of congruence between what the Constitution says and what the formalized rule will dictate as the way to operate going forward. I want to hear you on that.
Okay, let me answer you very directly on that. The fact is, the Constitution says, and I think it may be under Section 110 or whatever it is, that speaks to it. That says effectively you have a right of appeal once there's a particular threshold met, or in instances where Parliament may make orders in relation to prescribed matters, right? Now, the point I think Council have been making, with which I agree, is that because there is a clear constitutional provision as to how these things are to operate, if it is that what is happening is now depriving you of a constitutional right of access, then there is a problem. I will say this, however, as we make the argument, that courts, wherever you find them, have the right to regulate their own proceedings for efficiency and so on. However, regulation of proceedings, in my view, does not extend to regulating out a substantive right. What has been established, in my view, are clear substantive rights under the Constitution, and I don't think the capacity of a court to regulate its own proceedings permits it to regulate in such a manner as to deprive people of constitutional or other established substantive rights. So I quite agree with them.
And with that in mind, Dr. Malcolm, the constitutional issue that we're discussing here, plus the new issue of the consultations, the governance aspect that you said was not done, is there a reason should the government know, the Prime Minister, the Justice Minister, somebody from government be lobbying the JCPC, the UK government on this matter?
I think it goes beyond that, and I've said in another context, frankly, where I'm in discussions with some other persons, that I think it goes beyond that. I think the bar associations from across the region that have not gone to the CCJ, in my view, should write directly to Lord Reid. At the end of the day, Lord Reid is the head of our judiciary, as I've said. And they should write to him directly to say, we are aware that there is this intention to bring these rules in formally, because I think it has been happening. In October, we have not had an opportunity for consultation, and we wish for you to make a process of consultation available to us. So outside of the Justice Minister, I think that Kevin Powell, who is the president of the bar, in fact has the capacity to and should write for the bar, and other members of the public, in my view, could also write to this arm of their government, saying that we are hearing of these changes which have the impact, as we believe, to affect our established rights, and we would wish to have consultation on it to determine how best to proceed. I think it's a matter which should be taken on right now, head on. And the media has a critical role to play in this, I must add. But if we focus narrowly on the constitutional without taking it in the broader context of governance, I think we do ourselves a disservice.
Well, here's the thing. You know how this conversation will always boil down to a CCJ versus Privy Council decision. But here's the thing. If it is that a country, legislatively and from a governance perspective, is chasing down a rule, in other words, the rule is poised to be made, and then the legislators are reacting to that to try to put the legislative house in order to accord with what the rule sets down, rather than, as you said earlier, the thing being discussed with the legislators to say, okay, this is what our intention is. How can we make this work so that the rule is in keeping, is in harmony with what is on your law books? That's not what the situation is in this case, according to your reasoning. So I'm saying, isn't that reason for those who say, see, the Privy Council, again, the overlord behavior, signal rule to be made, make rule, and then leave the natives to go and fix their legislative house to get it in order. That's why we should move on and tell them ta-ta.
I depart from you there.
Yes.
And my position has firmly and very publicly been in favor of the CCJ for many years. In fact, I spoke at the very first conference that they had in 2005 or thereabouts, even before the court had started taking cases on invitation. And if you look at the Max Planck Encyclopedia of Public International Law, which is the premier encyclopedia of its type in the world, the chapter on the CCJ is written by me. So this has nothing to do with my views about CCJ, Privy Council, or anything. And my position has long moved beyond CCJ, Privy Council, notwithstanding my position, because I think we have to ensure that whether we're served by the Privy Council, the CCJ, or some final court of appeal that Jamaica decides otherwise, we need to ensure that processes are properly followed and that the best interest of the public is served. That is my primary objective, quite frankly. So I'm saying this is beyond that. And that is why I'm saying this is not just about the legislature. This is also about the bar and the public more generally to say, Privy Council, how are you going around this way? We're not talking simply about change of legislation. We're talking about a position being adopted to say there are established processes. You are accountable to us as a court. And you're accountable not just to the UK, because the moment you continue to sit as the final court or apex court for Jamaica, you are subject to our laws and our procedures and the way we do things. And you must be mindful of that. And you must bring us into your confidence. And you must involve us in an appropriate way.
Yeah. Really appreciate the perspective this morning, Dr. Malcolm. I'm certain it would have helped a lot of people. Thank you for your time.
You're most welcome, and have a wonderful rest of the day.
You too. Director of the Mona Law Institute, Dr. Christopher Malcolm there. We're turning to a matter that developed overnight. A policeman shot and injured in an incident where members of a police party attempted to enforce traffic orders against two men traveling on a motorcycle. The men, it's understood, sped off, opened fire, an exchange of gunfire. The men, well, at least one of them, shot and killed. Policeman shot and injured. Passerby, a man walking, going about his business, shot and injured in the exchange. happened on Bay Farm Road, Kingston 11 on Sunday night. Who do we have there, Towner?
Head of the Public Safety and Traffic Enforcement Branch, PSTEB, ACP Gary McKenzie. Good morning to you, ACP.
Good morning to you, Towner and George. Good morning to listeners and viewers.
Thank you so much for joining us here on Nationwide this morning. ACP, we gave a brief overview of what happened. I don't know if there are any gaps within the circumstances as you have it so far that you want to add.
Well, I don't know what you gave out, but what I'm able to say is that last evening, around about 5 thereabout, police officers from the Public Safety and Traffic Enforcement Branch were on patrol duties when they saw a motorcycle driven by what appeared to be a male and another male riding on the motorcycle as well. They were not wearing helmets. They were instructed to stop. They disobeyed it. They proceeded to drive dangerously along several roadways. The police officers gave pursuit, and on reaching along Coconut Crescent, that is off the Bay Farm Road area, they alighted the motorcycle, fired on the police. The police returned the fire. Unfortunately, the policeman was hit, and one of the men was hit as well, and both persons were taken to the hospital. A passerby was also hit. You know, I'm very happy to say that the policeman is not serious in terms of the injury.
And the bystander?
Well, the bystander is not serious as well. The person who was hit, one of the gunmen, is actually in hospital at the moment.
And on the scene at that time, the police able to seize the firearm that the injured gunman used?
No, not at all. The motorcycle was seized though, and the police, of course, the investigations have started, and the police are following some leads. So that is what had happened.
And what of the injured gunman? Any information about him, who he is? Was he on the police's radar?
Yes, we have information on him. We know where he's from. We know a little bit about him. We just need to put our pieces together. That is what happens with the investigation. I just want to say, though, that what has happened underscores the problem that we have, especially with motorcyclists. We know that the motorcycle is a mode of transportation that is used by a lot of very decent citizens, but they are also used by persons who intend to shoot and kill as well. The mere fact that they decided to take on the police is an indication of that.
Mm-hmm. And lastly, before you go, ACP, I've always wanted to know, are there special rules that apply in terms of wearing a motorcycle for people of the Rastafari faith who, obviously, unlike you and me, who can slip on a helmet because we have no hair on our head, there's a particular challenge there. What are the rules for them?
Well, the rules are clear. I mean, you are supposed to be wearing a protective helmet. So if you are a Rastafarian, you need to actually...
I mean dreadlocks. We should say dreadlocks because Rastafari can be bald-headed. But right. So dreadlocks,
so
yes.
If you have dreadlocks, whether or not you are a Rastafarian or you are just wearing locks, it is incumbent on you to put your hair together and to get the type of helmet, the size, that will enable you to wear it. The law is the law.
So there's no provision because I have locks, I can't wear a helmet?
No, it is not a matter of the fact that you have locks, you can't wear a helmet. What happens is that you will need to ensure that the locks is I would say, fit the type of helmet that you want. I mean, there are different size helmets, and there are different ways in which one can put their hair together so that the helmet is fitted to protect it. There is nothing to say that all the hair you have needs to be under the helmet.
Yes.
But the helmet needs to be properly fitted on your head.
Hear you on that.
I have a final one before we let you go, ACP Mackenzie. The police had put out a list of persons with outstanding warrants, asked them to turn themselves in immediately. Have any of them come forward?
Yes, several have come forward, and we will be treating with them. We expect that more will come forward. If they do not, we will continue the process of finding them. We intend to also promulgate more names, and we depending on how the process goes, we might very well put up photographs as well. But the intention, the goal is to ensure that we have a very good road safety network. And so all these activities are geared towards that. If persons are prosecuted and they do not attend court, then the matters are not resolved. And what we may find is that we could have repeat offenders, persons who drive carelessly, commit these breaches 1, 2, 3, 4 times, and they are still out there. And so they are a danger to themselves and others. Our responsibility is to ensure that the circle of enforcement is completed and the matters are adjudicated as required.
Hear you on that. Thank you for your time this morning, ACP. All the best.
You are most welcome.
That's head of PSTEB, ACP Gary Mackenzie. Right. So I see people, asking about the locks thing. It's just out of genuine curiosity, because I often see when the police are enforcing the no helmet rule, someone like Jermaine who has no hair, myself, I have no hair, we're riding without a helmet, pulled over. But sometimes you see a man with the crown on his head, crown of hair, because of the locks. And, he expects to be let go because, like I said, but Squaddy, there's no helmet that can fit this. So I'm happy to hear the head of PSTEB saying that there's no allowance that should be made because you have locks. You organize your hair in a way that you can hold under a helmet. Someone in the chat named
Let it down.
Let it down named Glorious EM says, George, our bearer has locks. Who's that? Who's Glorious EM? I don't know who that is.
I don't know either.
But our beer locks thin still, I mean, Trailer locks no. I know. Jermaine looks at me funny. Jermaine, you never see some Rastaman out a road ride by a kid with some head with a crown.
Yeah.
Yeah.
And they wear their tam, so it's all wrapped up in the tam. That
Junior Gang
can't fit
can
on
wear
the
helmet. Junior Gang could wear a helmet. Look, think about it. Junior Lagang locks gone.
He could, but it would be difficult to put it on and get it off. Because he's gonna let it down.
First of all, Junior Gang need a big knapsack to put the hair in. That's one. Then, but it will still be bunched up at the crown. So,
or he could wrap it up and tie it at a certain point on his back.
You said the struggle is real,
yes,
and that's why it was important to just get an official thing to see if, because of these challenges, there's any pass given. But the ACP says no. Mm-hmm. Organize your hair and get an appropriate helmet that can hold the hair as best as you can organize it.
Yeah.
And that is that.
And it's good that some of the people who have traffic warrants have turned themselves in.
Your name was on the list?
My name was not on the list, and I have not seen your name either. but what I wanted to say though, George, is that I like this new initiative by the JCF. They had Wanted Wednesdays, seems to be working. Now there's this initiative where persons with outstanding warrants, this one is called Traffic Thursdays.
Yes.
There's Wanted Wednesdays for persons who are wanted for various offenses. And now, in particular, Traffic Thursdays is for persons who are wanted for traffic offenses. And this list had about 70 people. And I forgot to ask ACP Mackenzie if the person with the most warrants has come in. Mm-hmm. Ansel Thompson, 70 warrants.
No warrant.
It's a lot of warrants because there's nobody else that even comes close to that. Yeah, 70 warrants.
That's a little bit more than the angry Pro Box man
driver.
Mm-hmm.
Yeah,
61. 61. So he's 9 short of Mr. Ansel Stewart.
Ansel Thompson,
Ansel Thompson.
70 warrants.
Yeah, Mr. Thompson, or anybody knowing him, the police want to speak with you, sir. All right?